Hello, I'm John Peters. Here at Hill Planning, we recently secured planning permission for a retrospective outbuilding at a semi-detached property in Halifax, West Yorkshire. The site lies on a steep slope within the designated greenbelt, and the structure in question was already built prior to approval. The outbuilding was intended for the use as a home office and garden room and measured 8 metres long and 3.5 metres wide and just under 3 metres in height. While modest in scale and discreetly positioned, the building was constructed without prior planning consent. The planning consent was required due to a condition placed on an earlier permission in 2015. With that planning permission, it was approved and it removed the permitted development rights from the site. Once the property went on the market, the lack of planning permission was preventing the sale of the property, and the existing owners were informed that retrospective permission would be required to regularise the structure and avoid enforcement complications. The case came to us via our free, no-obligation telephone consultation service. This was another case that I personally assessed, having looked at the site history, design and policy context. We determined that despite the Greenbelt designation and previous removal of permitted development on the site, a retrospective planning application stood a chance of success if presented correctly. Following the consultation, we issued a detailed written proposal setting out the steps involved and our associated costs. It was pointed out that to the client that it was highly likely that there would be some additional third-party reports that would be needed, and that these would be additional to our fees. The client was then able to make a fully informed decision before proceeding. We prepared a comprehensive planning statement that demonstrated the development met with 2 exemptions to inappropriate development in the Greenbelt under national planning policy. First, it qualified as an extension to the main building. We referenced key law concerning that detached structures within the residential curtilage can still be considered extensions. Second, we showed that the building replaced several lawful but dilapidated outbuildings, making it eligible under paragraph 149D as a replacement building that was not materially larger than what had been there before. We also addressed local planning policy demonstrating that the outbuilding enhanced the visual character of the site, respected local design principles and did not negatively affect neighbouring amenity or openness of the Greenbelt. Photographs, aerial imagery and historical evidence helped support the argument that the new building reduced overall built volume on the site by more than 30% and significantly improved the visual appearance of the land, which had previously been cluttered with deteriorating structures and debris. Calderdale Council approved the retrospective planning application on the 8th of August. Pre-commencement conditions were minimal, relating primarily to compliance with materials which were standard for retrospective consents. This case is a great example of how well prepared planning arguments, knowledge of case law and proactive response to site constraints can overcome what initially appears to be a highly constrained situation. At Hill Planning we have a history of delivering a successful outcome across England and Wales, even for complex retrospective applications. If you're considering a new or retrospective planning application or need help resolving a past issue, our team is here to help. Speak with our new case support team, who will arrange a free of charge, no obligation consultation and assessment of your case by completing our online inquiry form at heelplanning.co.uk. We look forward to supporting your planning journey. Thank you for watching this retrospective Greenbelt planning application case study video, and I look forward to producing the next case study video very soon. Bye for now.